Get ready for the dictation in 3, 2, 1, start. Sri Saket Sikri, learned counsel for the appellants, vehemently contended that the High Court acted on the erroneous assumption that the alleged 1996 GPA in favor of respondent number 2 is genuine. The original copy of 1996 GPA has not been recovered by the police till date, and hence custodial interrogation is required. Furthermore, the High Court failed to consider that despite the 1996 GPA being executed in favor of respondent number 2, he applied for its certified copy only in February 2022, that is 26 years later, whereas he should have possessed the original already if his claim is to be bona fide. The present case is one where respondent number 2, in collusion with other accused persons, has carried out an elaborate fraud against the appellants, who are vulnerable owing to their age and the NRI status. Additionally, the signatures used by appellant number 2 during the period between 1990 2000 are dissimilar, unlike, and non identical from those inscribed on the alleged GPA dated 18/9/1996. In addition, the consideration of the alleged sale deed rupees 6.60 crores is far less than the market value of the subject land, which is stated to be rupees 50 crores. Ms. Bansuri Swaraj, learned additional advocate general, appearing on behalf of respondent number 1, state of Haryana, strongly contested the grant of anticipatory bail to respondent number 2 and supported the stand taken by the appellants. It was argued that a strong prima facie case has been made out against respondent number 2 and that his custodial interrogation is vital to the objective of unearthing the larger conspiracy. Shri Maninder Singh, learned senior counsel representing respondent number 2, vigorously defended High Court's view and asserted that each and every allegation, contention, and submission made by the appellants was factually and legally incorrect. Learned senior counsel argued that respondent number 2 had originally purchased the land in caution from the appellants in the year 1996. However, at that time there was a third party lease existing on the land. In order to address this, the appellants executed 1996 GPA, which was duly registered at the office of the Sub Registrar Kalkaji, Delhi. This GPA has not been disputed in any court of law and has not been challenged by the appellants up to the time the civil suits were filed, clearly showing that the contestation of its validity was merely an afterthought. Respondent number 2 had full authorization through the 1996 GPA to execute a registered deed of convenience for the property in question and receive consideration for it. On 24 to 2022, respondent number 2 sold the land through the exercise of power vested in him by virtue of the 1996 GPA. However, the purchasers have not been included as parties before this court. The authenticity of the GPA have not been included as parties before this court. The authenticity of the GPA had been verified according to the report of the sub-registrar Kalkaji dated 13 to 2022, and the sale of the land only took place after the receipt of the verification report. Stop.